Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of November 19th, 2020. My name is Lisa Minton, and I will be presenting the cases to the board for their review in today's public hearing. We're convened here at the Sonny West Conference Room, located at 700 2nd Avenue South. For these public hearings, the board reviews the correspondence submitted in support of and opposition to the cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, if anyone is here wishing to speak in support of the appeal, they may do so. If any opposition is present, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested by the power to act on these cases under the provisions of Metro Zoning Code Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I'll introduce the entire zoning code and make it part of today's record. The Metro Zoning Code requires a record of these proceedings. Because BZA meetings are recorded for a Metro Nashville network, it is imperative that anyone addressing the board come forward to the podium and speak into the microphone. All speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. The applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled.
Great, thank you. And I would like the folks in the back, folks in the back who are talking, we can hear you all, and I know you're trying to be quiet, and I appreciate that, but once we start the meeting, if you all continue talking, that's perfectly fine. Just step outside if you don't mind. And just as a reminder, when we start the meeting, because of the COVID situation in the city and the state and the country now, I appreciate everybody wearing your mask, but when you come up to speak, but either at the microphone or at the table, please leave your mask on, covering your nose, your mouth. I know it's difficult, but it's just what we all have to do. But again, appreciate everybody's attention to that today too. And so, continue.
Mr. Chairman, we do have a few preliminary announcements regarding deferrals. Case 2020-230 has been administratively deferred indefinitely. Case 2020-233 has been deferred to the December 3rd meeting. And case 2020-234 has been administratively deferred indefinitely. For members of the board, our public utilizes a consent agenda at each of its meetings. One board member reviews the case records for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines the testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to the case is identified for the consent agenda We will remove the case from the consent agenda and hear it in its regular order. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First case, case 2020-227, located at 148 Fane Street. Is there anyone here in opposition to case 2020-227? Seeing none, the next case up for consent is case 2020-236, located at 2318 Woodmont Boulevard. Is there anyone here in opposition to case 2020-236? Seeing none, Mr. Chairman, staff would solicit a vote to the board at this time.
All right, have a proposed consent agenda. Is there a second? Second. Have a motion, have a second. Is there any discussion? Okay, all in favor of the consent agenda, raise your hand, say aye. Any opposed? That motion passes.
Members of the public, if your case was just approved on the consent agenda, please give our staff until Monday to process all the documentation associated with your appeal, at which point you may come in to pursue those permits for which you have applied. Mr. Chairman, we do have a previously heard case requiring board action, case 2020-211, located at 012th Avenue North.
Okay, I think that Mr. Newton had not heard that case. Did you have a chance to hear that case?
I have, yes.
Okay. So I believe at this point, all board members present have heard either in person or by reviewing the materials in the meeting, have seen the case and can vote. And it's been so long, I can't remember if the last vote that failed to receive votes was to deny the variance or to approve the variance, but it didn't receive enough votes. So do we have the slides at all?
I do have the slides available.
Just to run through real quickly to tell us what this case was about, and then ask if there's a motion.
This was a variance from the minimum lot size requirements in the R6 district to construct 2 single-family homes. And I believe it involved 3 separate parcels.
Yeah, it may refresh everybody's memory. So does would anybody like to make a motion?
Well, let me make sure
or discussion?
Yeah, I want to make sure I remember the case.
There were three lots, I think. One of them was the right size. The other 2 may not have been. They wanted to build 2 homes on each lot. They were, if I remember, there were lots in the neighborhood where new homes were being built, but very few where they had 2. And I think it ended up being, I think, 6 feet between each of the homes, 3 feet on each side. And they weren't asking for a side setback. They were just asking for a lot size variance. But
It was a side setback and lot size variance?
no, it was just a lot size
And
variance.
it was, as I recall, it was in like 6%. Was that what it was? Or
I think it was less than 5%.
Okay.
I just watched
I
it
remember it
recently.
now, so,
And
yeah.
so it was like 6,000 square feet was the minimum. I think they had 5,749 or something
Okay.
right around there.
Thanks. I remember it now that you say that. Thank you. Yep.
And I don't remember do we remember how the council person weighed in, or if they did?
The council person was against.
That's what I thought. The council member came out against it, and
I believe the last motion was that Mr. Pepper made to approve, and it was 2-2.
all right, great. Since you just watched it, and then, so I should have just asked you to give us the overview. Sorry. All right, so it was. So the motion was to approve the variance, and it did not pass. It received 2 votes for and 2 votes against. Is there? And if there's no motion today, or if a motion doesn't pass today, then the case will be denied by lack of receiving 4 votes. So I will ask, is there a motion?
I will move again to approve the variance.
All right, and is there a second?
I'll second.
All right, there's a motion and there's a second. Is there any further discussion? All right, everybody who's in favor of this motion, raise your hand and say aye. That's 2. Are those opposed? Raise your hand and say aye. That's 3. So that motion does not pass. And I'll ask our staff and legal team, is there a need to have, at this point, a motion on the other side, assuming that it will receive 3 votes to 2?
While the board can, in fact, take a separate motion, there's no need to do so.
Okay.
If there's no such motion, the case is concluded by operation of law. You can move on to the next matter.
All right, so then we'll move to the next case.
The first case to be considered is case 2020-224, located at 1001 Aladdin Drive. They're requesting a variance from the 28-foot contextual front setback and requesting a setback of 29 feet for a enclosed front porch that was started under construction without a permit. I'll go through the slides, and then I will see if there's anyone here in opposition, and then the appellant will have time to speak at that point. It's an aerial parcel view showing the location. Here's your aerial overhead view. This is the contextual setback survey with the subject property with the footprint of the addition that is under construction. There's a street view showing the subject property, the neighboring views. Is there anyone here in opposition to case 2020-224? Seeing none, the appellant, you may state your name, address, and state your case.
Ma'am, if you would push, there's a little button that turns a red light on. There you go. And just state your name and address and tell us why you're here.
Thank you. My name is Danita McCluskey. I live at 1001 Aladdin Drive. My husband and I have been there about 25 years now, close to. We are asking for a variance from the contextual setback. When you look at the survey that is up there, I've tried to get a hold of the company that did that survey because it is different from the one that I have from when we purchased the home that shows the amount of footage that we have on the front. It's not a big difference, it's only 3 feet, but I'm also not asking for a lot of footage, so every little bit helps. I should have that picture in there with pictures that I sent in, but I don't see it up. The difference is of 3 feet, so instead of asking for 9 feet, I would only be needing 6 feet over the contextual setback. Yeah, and that is it. It's for an enclosed front porch. I call it a sunroom, 3-season room. That's it.
How deep is that sunroom?
I'm sorry?
How deep is the room? You need
It's 10 foot wide, and it's not quite the length of the house. We stopped it just at the front bay window. So as you see, it's really small on the picture up there, but at the bottom of the screen, it doesn't quite come all the way over. There's like a 2.5, 3 foot difference.
And is it air conditioned? Is it?
No. It will have hardy plank siding. It'll have windows all across the front and a tin roof.
And then why was the choice made to enclose it instead of having it as a porch?
Okay, we have a lot of water issues on this house. I brought the receipts. I wasn't able to find them to turn in before the deadline, but I have receipts on the water heater, the air conditioning unit. We've enclosed the bottom of the house, the basement areas. We have spent so much since the beginning of the year trying to locate where all the water damage to this home is coming from. From what we have been told, it could be anything on the front of the house, from the gutters to the windows to the doors to the porch to the siding, and we can't go through every little thing trying to find it. So it was just recommended, our best option was to close it in so that no water could hit the front of that house. We also have an issue with water runoff. The house that is at the top of the screen next to us, there is a street in front of it. It's got an ever so slight hill to it, and that water comes down that hill, hits that neighbor's driveway, which they built up concrete, and it's so thick with a tilt towards our property that all that water runs off towards our house. When it rains really heavy, it looks like a massive river in front of, right up against our property. And it causes a lot of heavy puddling. With my mom being disabled and fixing to having to go to electric wheelchairs and whatnot, that was also the best option to be able to get her into the house without hitting all that water that's in the yard.
Okay, and so, but that, I guess back to the question I'd ask, and I appreciate all the things, the other issues you were talking about, but
Sorry.
the question was, why does it have to have walls and windows? You know, a well-eaved front porch is not gonna allow water. Why does it have to have
Well,
walls?
the way the rain in that area is, it would. I mean, it just pounces against that house from the front, so it would still completely blow in. We have a deck on the back of our home, so we already have experience with it where it blows straight up against the house, even screens. So I don't see that that would help me solve any of it. But I also have the issue of really needing the space to store her handicap equipment because there's no space in this home. There's like one closet for 2 rooms. There's no room, so I just thought that would also help us.
If you need additional space, can you add on to the back?
No, we don't
Why?
have that option, unfortunately. That home has the electric all in the back, all the water lines and everything else. And out in the back, there was a pool that was put in the beginning when we first bought the home. And we also have a deck in the back, so we would have to tear all of
You could,
that
it just
up.
cost a lot more, I'm guessing.
A ton more, yeah. Also, there is a previous garage that is on the back that is catty corner to the home that would interrupt building back there unless it was a really odd shape.
Ms. McCluskey, I'm Ross Pepper. It took me a second, but I'm 90% sure I represented you a few years ago in a legal matter.
I remembered your
Okay?
name, yeah.
And the reason I'm asking is I'll need to recuse myself because you're a former client, so.
Oh, okay.
But yeah, good to see you again, but it took me,
Okay.
I thought I recognized your
Yeah,
name. and then
I think I came into your office, but I never saw you after that. But yeah, I remembered your company when I saw your name.
Yeah, I think my firm represented you.
Yeah.
Okay, yep, I need to, Mr.
Okay.
Chairman, I need to recuse myself.
Okay.
Yeah.
Well, you presented a lot of pictures of what it might look like, and there's a wide range.
Those are just pictures of different ways people have done stuff in the area, in our
Right.
neighborhood. I didn't want to take a picture of every single thing, but I wanted to give you like a little bit of everything that's over there.
Well, and you know, we have a handful of letters of folks, neighbors, people that say their neighbors opposed to this, and we have a note from your council member saying that he did not have an issue with it. He
There
said,
was opposition in the neighborhood, though? Wow.
well, you know, people don't usually write, I can't tell you
Yeah.
what street they're on, but people usually don't write unless they got the letter. But, you know, somebody on Conley, somebody somebody that just says they're a concerned neighbor.
I don't
somebody
understand
on
how it would
Aladdin.
affect them. I'm not even on the same street.
Yeah, there's one on Aladdin. But anyway, I guess the question I'm struggling with, it's not unusual for this board to grant a contextual over a variance for homes of your era that, for a front porch, especially homes that don't have a front porch. It's a little rarer for us to grant
To be like a sunroom.
a variance for a completely enclosed space.
Well, I also might add, my
And-
daughter is allergic to bees. So, I mean, that was the main reason she begged for it to be enclosed so she could enjoy the outdoors.
Right, well, and a lot
But I
of people
mean,
do that
that's-
from screening and that kind of thing. So I guess
Yeah.
that, and again, I don't know. I mean, I don't know that that's a question. I should have asked it in a question, but it was really more of a, these are the issues that I'm thinking of at this point, and giving you a chance to respond to those before we have to discuss.
Yeah, and I mean, I'm not going out any farther than other people on the street have. Due to that contextual, it limits me to just the houses on each side of me. And that particular picture, it doesn't do justice to show as you go the houses in each way, how they kind of alter in and out. And then when they've built through the front, they're out even further.
Yeah, and we have a couple architects, and the staff has stepped out, but they can tell us exactly how that contextual setback is set. And I think it's more than just the houses on either side. I think it's maybe a couple, 3 or 4, 2 on each side, so it's a total of 4 homes. Which you're right, in some neighborhoods that does impact the property owner, and if that were to be the argument for your hardship, then we would probably want to have more information to say, well, here, you've shown us a survey that has 5 homes. What do the 15 on the street look like? And if it's, does that present a case for you to have something that much closer to the street? But are there other questions at this point?
But yeah, and according to my original survey, though, I'm not at 29. I would be at 32 and 35 on each side. So that
So
would
you'd
put
be
me
asking
over
to
the
go from
30.
38 to 32.
I'm sorry?
So you're asking to go from 38 to 32, the 6 foot. You want six additional feet.
Right. If you go by my original survey, this one that I just paid for, I don't know why, it shows like a dip in the picture towards my house on the road. And for some reason, it doesn't show the actual footage. Like there's 3 feet of discrepancy according to my original survey. I don't know if you guys had a picture of that or not. If not, I've got one here. But it shows that I have 44 feet and not 41. So that would give me an additional 3 feet. So instead of 9, I would need 3.
Okay.
6.
All right, any questions? Did you have anything else to add?
No, that's it.
Okay, I'll close the public hearing and ask for a discussion. I'm sorry, there's no opposition present, is that correct? Yeah, there's no opposition present. It's just the letters of one support and a couple neighbors in the file.
My thought just would be from looking at the aerial view on the street, I mean, it's a pretty uniform street looking at it. And I think the only things that kind of encroach in that uniformity are, a few little open porches, but those look like they're, no more than 5 or 6 feet sticking out from the house. So this really seems like a stretch to me to give additional square footage for the house out in front, or give enclosed space out in front, especially since there's a whole back. I mean, I realize that there are things to deal with in the backyard, but there's things to deal with in the front yard too. I mean, there's
That wouldn't help me with the water
Ma'am,
issues.
the
though.
public hearing's closed,
Sorry.
okay? So this is just for our time to discuss what we've heard. Thank you.
And I understand that there may be some water issues, but there's a lot of houses that have water running up against them, and that people find ways to deal with it, and it's manageable. I mean, I have that in my own house, so it's something that's very manageable through other means rather than building on in addition to the front of the house, is what I would say. So I'm having a hard time seeing the hardship, I think, is what I was trying to say.
Well, and again, if it were a screen porch, and it maybe took up a little less than, space, I might be a little bit more amenable. I mean, even open might be preferred, but again, understanding that issue with bees and the daughter and that type of thing, I think a screened, but then enclosed with windows and no HVAC creates other issues with the home anyway. And like I said, I'm kind of with you all that I mean, while I don't see it, I'm almost. I also feel like that I would be willing to, allow the applicant to come back with another plan prior to the timeframe, having heard the concerns and issues. But I don't see, without more information, I'm having a tough time on that path too. So I don't know where the rest of you are, but.
Well, I'd be willing to grant the variance request to do the screened-in front porch.
I think I could support that if it was less of a variance than it's showing right now. I think it seems like it's a lot right now to be coming out in front of it.
Did you have a thought?
I was a little concerned that they started construction without first doing all the necessary stuff, and then I sort of agree that I don't really see a hardship, but I would be willing to support some sort of variance, like a screened in, and maybe if it really is like a irregularity with the survey, which I know that those happen, just doing the 6 feet so that we're sure that it's not going to be ahead of all the other houses along that line.
So and that's a tough one too. I mean, does it go from 38 to 32? Do you allow to go to, what's an appropriate screen on that one?
I think a 6-foot wide porch is plenty enough.
But and I thought that there was 10, she said it was 10, wanting 6. I think they already must have 4. So do you just give a 2-foot variance? Or do you?
I guess I'm not reading the drawing that way.
I think it would be the variance would mean putting the setback line about 35 feet. Because if her current front of the house is at 41 on that closer side, that would mean that a 6 foot from that would be 35 feet. Which appears to be about in line with the front porches of the neighbors around
So
there.
that would be a 3-foot setback variance. If the contextual is at 38,
It probably is easier to define it as what the setback is from the right-of-way line than say 6.
Yeah, I would agree there.
Yeah, like how you were doing it is good. Would you make that a motion?
I will make a motion that we, based on the homes around to allow a setback of 35 feet for an unenclosed porch.
and the understanding that unenclosed means no walls, no windows, that it could be
Correct. You
screened.
could screen it, but.
Could be screened, but it would basically have a railing and supports, no walls and windows.
Yes, that's.
And that's what and so without an additional plan, that's what the applicant would be eligible to do. And if they wanted to do more, they'd have to bring another plan back.
Right, yep.
All right, so that's the motion. Is there a second?
I'll second, and I'll add that a roof is allowable.
What?
I'll second, and I'll say that a roof is allowable.
Oh, yeah, that it's a porch. It's just a covered porch that could be
Covered
screened,
porch.
but not enclosed.
Yep, that's good with me.
Okay. Is any other discussion? All right, then we will vote. All those in favor of the motion, say aye and raise your hand. Any opposed? That motion passes 4-0. All right, so that's it. So good luck, and you can.
So what am I supposed to do? How,
The motion was to allow you to build at 35 feet from the property line, a porch with a roof and railings, but you can't enclose it, no windows, no walls, and you could screen it. And if you want more than that, then you've got to bring us more information. But at least it allows you to do.
what more information would you need? Because we already started it that way, so I don't know.
Right. what I had said before, and we got other cases, we're gonna go to that, and you can talk to the staff, at some other point. But you didn't present a hardship other than your own property. You only have, your survey only has 2 properties, so there's no real context to say, hey, I really do need to go out further, and the other houses way down the street or 3 houses down do. And we don't know what it's gonna look like. And so, I mean, and how does it work? I mean, right now it's just a frame, so we'd have to have a.
Yeah, I sent in a picture of what it
Yeah.
would have looked like.
Okay.
I don't know why they weren't up there.
All right, well, it didn't make it in here, so again, you have some permissions that you didn't have before, and you have a path to get to something more if you choose to do that. So
Okay.
that's all we can do for you today.
Thank you.
So we'll go to the next case.
The next case is case 2020-228, located at 115 Mount Vernon Drive. Requesting a variance from the 16-foot overall height restriction for an accessory structure. They're requesting 17-foot 8-inch overall height for a pool house that is currently under construction within the RS-15 district.
My name is John Gregory.
Sir, I will present the slides.
Yeah,
and then
she's
I'll
gonna-
let you
Oh,
speak.
sorry. I was up close.
Is there anyone here in opposition to case 2020-228? Seeing no opposition, I'll proceed with the slides, and then the appellant will have the opportunity to speak. Here's an aerial view of the property. Here's the site plan that was submitted showing the proposed pool and the pool house that's under construction. Here's a view of the pool house provided by the applicant. Property. Since there's no one here in opposition, the appellant, please introduce yourself by name, address, and state your case.
John Gregory, 115 Mount Vernon Drive. What we have here is 16 foot is the minimum that y'all said, but we went over to 17.8. That's just at the peak of the building right there. Everything, it's about 1.5 feet from the peak is the over. So everything below it on the sides is in tolerance of that. I'm just asking for the 1.5 feet, 1 foot 8 inches.
And what happened? Why did it get built smaller than it was, or taller than it was supposed to?
That was a mistake on my part. I am the self-contractor for the house. And being the soft, okay. Yeah.
Mascot, no, cover
Oh,
your
yeah,
face.
okay. Yeah, it was actually my fault on the bill, just miscalculation. So we went over 1 foot 8 inches.
Is the roof pitch the same as the primary structure, the primary residence?
Oh, it's pretty close to the sunroom, which is right behind it, the same pitch pretty
Okay.
much. And you cannot see it from the road, and it's not higher than my sunroom itself. That's coming off the deck.
And it doesn't have a second story?
No, it's all open.
Okay.
So you said that it kind of slopes back and you can't, it's not visible from the road at all?
Yeah, you can't, if you're looking straight from my house, you can only see it, period.
Yeah.
There's only one side of it that you can see a glimpse of it. That's the front view right there.
Any other questions? All right, anything else to add?
Nope.
All right, we'll close the public hearing.
Even though, like I said on the last one, I don't like when things have already constructed and people come to us, given how small it is, and that you can't see it from the road, so it doesn't necessarily detract from like the line of sight from the street, I'm inclined to support such a small variance.
Yeah, and especially since it's not, doesn't have it wasn't trying to get a second floor when, you couldn't, or make the second floor taller. It seems like it was a pitch issue that you kind of figured out, when it was all framed up, and yikes,
While I would tend to editorialize that using an architect would avoid a lot of these issues, I'd be in the same boat there.
A motion from somebody? Or any other comments?
I move to approve the variance of 1.8 feet to allow the construction or the completion of the pool house.
And I'll second that.
Have a motion, have a second. Is there Any other discussion? All right, all in favor, say aye, raise your hand. Any opposed? That motion passes. Good luck.
Thank you, guys, appreciate it.
Next case.
The next case, case 2020-229, located at 1210 East Ireland Street. Applicant is requesting a variance from the 5-foot side setback for the rear 2-unit structures, units C and D. They're requesting a 4-foot side setback along the western property line to keep an existing neighboring fence in place, and it's located within the RM20 district. I will go through the slides, and then the applicants can state their name, address, and case. Here's the parcel viewer showing the proposed development of 4 units on the property. I believe the 2 rear units, C and D, are the ones they're requesting the variance on. There's the aerial overview of the parcel. This is the proposed site plan and the pre-existing conditions. The existing fence. And the street views. Is there anyone here in opposition to case 2020-229?
Ma'am, you're in opposition? Yeah. Well, you know what, I'm going to let you just be opposition, and so if he's going to make his case, and you just hear what you hear, and then if you can speak after, and if you have a reaction to that or other questions that you want to know, then just you can let us know how you feel about it after he makes his case.
So the appellant may state your case, and there will be time for opposition to speak, and then you will have a total of 10 minutes.
And if you would press the red button, just press the button at the bottom, make sure the red light's on. There you go.
Thanks, folks. This is a packet in front of you that I put a little clearer and edited and things like that to show it. Thank you. Mark Wallace, 340 Wandering Circle. And this is an interior lot property that we've had surveyed, and the first sheet on top of it shows really the issue is a highlighted line, is a fence line that Habitat, when they built these homes in 1994, the homes are all lined up correctly, but the fences and sidewalks are not. And highlighting shows where that fence is over the property line, and including there's a sidewalk there on just adjacent and running alongside that fence that is the neighbor's property as well, is the neighbor's sidewalk as well.
Have you asked them to move the fence?
No, we're asking to leave the fence.
Okay.
And, but
I'm just curious as to why the solution isn't to, if you have an encroachment, to have them move the fence. That's what,
yeah,
and
so
maybe that you got some kind of legal issue that it's been there
we're
so
just trying
long.
to, yeah, sorry, go ahead, sir.
No, that's just, I just wanted to know what's going on with that.
There's a lot of confusion about what we're trying to do, because it becomes contentious at some point, and then it just, people don't believe each other. And so what we're trying to do is avoid any possible issue just by moving the whole site plan over 1 foot, so we can leave a fence and the sidewalk that the neighbor believes is hers. And even though we have a survey to show and verification from Byron Hall, who then called Bill Herbert, that says we can take it down and we can remove what's on the property because there's no structure there. So we're trying to avoid all that and just move 1 foot over. But I can go through the rest of these sheets just to show the exact locations of everything. So then that's the survey. The second sheet, is everybody, sorry to, I have the neighbor to our west approves this lot line shift for both buildings to move to now a 4-foot setback instead of a 5, moving to the west. This is her statement. This is Jennifer next door. The neighbor's addresses, they're off numbered, but that's 1302 is the adjacent. So the third sheet, the first 11 by 17 sheet, is a pretty clear picture of the interior lot, the 2 buildings, and then the actual, I put a red circle around the fence, around that area, and then took a northerly picture to see basically the backyards. That fence is shown on the survey and on this picture as clearly veering over onto the property, and that the yellow lines are where everything matches with the survey. So there's a stake there that's called out that says the corner of the house stake is the proposed site plan. That would, if the way the site plan is currently drawn up is that stake would be on the other side of the fence. So so the fence is gonna run into the house and we would have to take it down. So if we do move 1 foot to the west, that stake that's where it would be, and that would be the edge of the house. So even though we're not giving up the land, we just want to be able to put the house there and hopefully leave the fence without damaging it, that kind of stuff. The next sheet is the current approved plans where it shows where it says on the very top in the red, it says current approved plans, and then you can see I highlighted the yellow sidewalk, and then there's that line with an X going through it, which is the actual fence. And then you can see how that clips with one of the circles there, that clips the edge of the house if you go to the right side, you can see how that fence line would clip the house.
You've done a great job with these diagrams, but to me, it's pretty simple here. You have a fence that's encroaching and you need a foot on the side. I mean, that's what it boils down to, it seems.
You're right. Sorry about it. This is probably overdrawn, and I get it, but.
A lot of people come up here and don't give us the clarity in the documents that you have, and we appreciate that. And these are very helpful.
And the last sheet is basically the proposed, which is you take both buildings, not just the back, or if it's one, fine, then shift it all over 1 foot. So it's now essentially 6 feet from our property line, even though that fence and sidewalk are still there. I would, however, ask that we can still use that 5 feet to build the house. See what I mean? And since she's here, it'd be a great time to discuss it.
So if you didn't get this variance, would you have to demolish the existing sidewalk that's there?
Yeah.
Okay.
Yep. Both the sidewalk, the majority of that sidewalk as it veers over, I think we would be happy to replace the sidewalk where it's supposed to be along with the fence, because we're going to put up a fence ourselves anyway. If that were the case, so it's not a. And that's it for me, so if everybody understands. Otherwise, I'm happy to answer questions or.
Well, I understand you're wanting to avoid litigation, especially contentious litigation. Was it just not, did you make a request that the encroaching fence be removed, and I guess that was declined?
Yep.
So the next step would be, I guess you'd have to file a lawsuit to
Yeah,
get it
so
resolved.
Sorry, I didn't mean to interrupt you.
That's fine.
So so in general, I went down to the Byron Hall, asked him what we should do. He said, and I said, is there anybody that can stop us from taking this out? He said, we're not going to stop you. You have a survey showing that that's on your property. But then he wanted to verify that, so he called Bill Herbert in front of me, and Bill Herbert said that there's one part of the law to where if there's an actual used structure that you're talking about, then it would be saved, or at least it would stay there to some degree. But since that's an open yard and since it's a sidewalk, that wouldn't apply. So it would be taken out at that point. And so by the time we even get to that part of the statement, the discussion's over with the neighbor.
Okay, thank you.
Yes, sir. Should I?
Any other questions at this point? All right, so we will hear from the opposition, and when they're finished, you'll have 6 minutes and 50 seconds for rebuttal. Right, yeah, ma'am, if you keep your mask on for us. And then press the button at the bottom, right there.
there it goes, the red thing. Yep, that's it.
Then the red light's on, and now you're good to go. Just make sure only one of them's on at a time, or you're gonna get that feedback. So whoever's talking first, the other one cuts your mic off. Ma'am, so just state your name and address and tell us why you're here.
My name is Marcia Jordan, and I live at 1208 Ireland Street. The address is right next door to, I have the fence. I've been there 28 years, and when I purchased the home, when we purchased the home, they divided the land and they put the fence up there 28 years ago. So then I'm the only original person there for 28 years. Everybody else has left, and another person purchased the house, and she had a survey, and that fence had to remain there. And then the person on the other side of me, they wanted to put up a fence, but they were told they had to put it right by the other fence. They couldn't move it. They called it adverse possession or something, because him and I went to a lawyer. We went to Kenny Reddick, and Kenny Reddick told him he could not move that fence. We done been through. He tried to buy my house for $450,000. I told him no. I did not want to sell. Everybody else sold. I love being centrally located because I work downtown. Okay, after that, he kept coming to my yard, and he told me a tree divided the land. He said years ago, a tree divided. He took me out to eat a couple of times, and then I have pictures because I'm gonna go to one thing from another. He told me a tree divided the land years ago, and I told him, I said, you almost got me convinced that this tree out here divided our land. I said, but years ago, I couldn't even own land or anything. I said, but now that I can, I said, I've been here 29 years. Here these big developers come. They give people money. They move us out. I don't want to go. He can have his $450,000. I just want my home the way I purchased it 28 years ago. But he told me that, the fence is his and everything. But I've been there 28, and they called it adverse possession. They said, if you owned it and been paying taxes on it over a certain amount of time, then it becomes yours, but somebody else purchased the house, and they did a survey, and they said it was my land.
Okay. And I'm sorry, ma'am.
You want to add something? Go ahead.
I would just say,
And name and address first, please.
my name is Courtney Jordan. I stay at the same residence. She is my mother.
Okay.
It's just been a contentious process because he's trying to purchase the land and then he was unsuccessful in purchasing it. He's made several attempts to just take it. And he's even cut the water off, cut off power. We just had this contentious situation back and forth for somewhere we've lived for 28 years. We had discussions about removing the fence. We don't want to remove the fence. He said prior to this that he was going to just try to go over because the lady that lives on the other side of call it the west side, stated that he could have an inch of her land, so it wouldn't be a problem. But then when we get here today, it's either he gets the inch or he's just going to remove the fence. It would just seem like it would be unlawful for him to come in our yard and remove the fence. It's just a back and forth contentious situation, and we don't want to remove our fence because it's been there 28 years and we haven't had any problems to the big developers come in the area and just want to take people's property that's been there for years and paying their taxes and been living here for years and upkeeping their property. And that's all I would like to add.
And so I guess that one of the questions I have is that, if he were to move his whole project over so it didn't mess with your fence, is that acceptable to you, or do you still have issues with that?
If, as he stated prior, that the other neighbor that owned the property said that he could have that into her land, we don't have a problem with that. We have paved concrete there that's been cemented and been there for years in the yard, as well as the fence. If he goes over the other direction, which he notated as west, we don't have any contention nor problem with that.
Okay. Any other questions for the neighbors? Was there anything else that you'd like to add at this point? And well, actually, anything to add? This is the only time you get to speak. So he'll get the chance to come back and respond, but this is the time you get to speak. So if there's anything else you'd like to add, now's the time.
Oh, I've had problems, just, I don't know if this will help, but, I asked him nicely, but they was letting all the paper from the houses come down in my yard. I asked him to remove it. He removed it one time, then we had to go out there and move it. Then he brought wires all through my yard without asking me underneath. He put them underneath my sidewalk and just trailed them all. And then I have grandkids that was out there playing with the wires. I don't know. It's too much. I mean, and then I had to write my councilman, Freddie. He told him, you know, we've been just going through this a long time. It's been about a year.
Have you heard anything from your councilman?
I did. He emailed some man with the appeals in here, and that's why he told me to come down here. We were sending all the pictures, and then they got my water back on. He called Metro, and Metro came out there, and the man was very nice and talked to me. He said, somebody just went and picked up the sewer thing and just cut you off. But I talked to Mr. Mark about it. He said it was kids. But I've been there 27 years. I've never seen a kid that would lift a sewer as hard as it is to lift and have the tools to cut it off. But it was cut off for two weeks. 2 weeks, no running water. None whatsoever. I think that's about it.
Any other questions? All right, well, thank you for coming, and we will hear back from the applicant.
Folks, thank you. There was, so we'd like to shift it over to the side. There were many errors in those statements that I'm not sure which are relevant to discuss, but I would be happy to. I'm not sure who turned off water. I tried to help her fix it. I thought it might be a corrosion pipe issue. Wires are undergrounds that we're doing for electrical that are next door, and we've since caution taped everything to make sure that people don't wander over next door for that. And there was some litter after big storms that come off as house wrap, and I was immediately over there. The first time I was called within I think an hour to be over there, and then we did speak with an attorney when we were trying to purchase her property. The attorney then never mentioned anything about the fence line. What we talked about was whether it was a good deal for her or not, and I was one who requested that we go to an attorney so that we could communicate effectively. So we're trying to save the fence, our adjoining fence. So that's what we're trying to do. We're trying to keep the sidewalk and keep the fence. That would be it.
Okay. Any other questions for the applicant? Anything else to add?
No, sir.
Okay. Then we'll close the public hearing. Yeah, I guess that, I think Ross had mentioned it earlier about, seemed to go down the path of why is it with us? Why are we having to deal with this question? Which is, I think, a lot clearer now, but still not very typical. We typically don't get in these types of situations. And I guess the only, it seems like the solution that's proposed isn't a bad solution for both neighbors. I wonder a little about, at what point, is it really a 0-foot setback if the neighbor's fence is and land is hers because she's had it for 28 years, and I don't think that's before us, but, I don't want to weigh in, frankly, on that dispute to say there's, because it sounds like we're taking sides on where this property line is, and that's not really our job. But I do think the solution of placing the construction where it's been proposed to maintain and keep the existing fence that's been there 28 years is not a bad solution. But like I said, to me, there's underlying, does that imply that we agree that that is really 6 foot off the property line when the neighbor has come out and said, no, the property line is the fence because I've had it for 28 years. And I don't know I'm not a lawyer, I don't know what the legalities are there, but we have a real estate lawyer sitting next to me.
I don't know that the lawyers know either, but I think I definitely want to help them keep the peace. I get uneasy when we're asked to give variances because there's unresolved legal issues between neighbors and that we're kind of this the default. But I think that there's two ways that you could view this. Is one, the hardship is a fence encroachment, which I don't know that it would really be, that's really a hardship if somebody's fence is encroaching on your property. But I think there is the possibility, I suppose, that there has been some kind of adverse possession, and now what you may have is really an odd-shaped lot because the adjoining property on the east now actually owns that little strip, and then you would have an unusual size lot that I think would constitute something that would be a hardship. But I'd like to hear from others because I definitely want to try to help them keep the peace. But this has happened before where people have come before us and basically had issues where it was easier for them to try to solve it by getting a variance than maybe asserting legal rights and having that resolved. And I'd just like to hear from, I definitely want to try to keep the peace, and I think one way to view this is that there is a hardship, but I'd like to hear from other members and hear what everybody else thinks.
Maybe simplifying it, but to me the issue is there's a request on the western side of the property to reduce the setback by 1 foot. And it's maybe oversimplifying it, but I don't think it has been shown, we have correspondence, that particular neighbor on the western side is not affected by this proposal. So I'm probably making it too simple, but to me, that's what we're analyzing, and to me, this seems acceptable.
Well, I mean, I totally agree with that. I just don't want either party leaving thinking that we weighed in on either side of who owns the land between the fence and the surveyed property line. Because I think, so if it were my fence and it were my property, I might be inclined to think, well, you need to build 5 foot from a fence because I've had it 28 years and I may have a right to it, and we're going to go to court and figure all that out. And yet the applicant's going to benefit, I think, greatly for solving it now in a better way. But like I said, I just don't want either of them, anybody going home saying, I don't mind approving the plan as presented, but I don't want there to be an assumption that there was an analysis on who owns the property. And if that means that it gets translated into, 6 feet or 0 feet, I don't care. But I think the solution is good. Does that make sense? Looking at my lawyer, who's looking at me like, what are you talking about?
I don't think we were asked to decide that, though. I think if we frame it the way that Christina framed it, we don't even have to touch that or discuss that.
Yeah, and that's good.
Can you say that again? I could not hear you.
I said that we don't have to discuss that or even decide those issues regarding the ownership or the other side or anything. All we have to do is, the way Christina framed it, I think is perfect. Like, if you narrow it the way Christina did and just frame it as western neighbor doesn't have a problem, it's a 1 foot variance, this is what the applicant requested, we support that because it's such a nominal amount, and I think that solves it.
And Not only that, but that western neighbor is not a recent, it looks like, based on parcel viewer, they've had it since 2007, so it's not like a recent, developer kind of deal. I mean, that neighbor has been there and, continues to be there.
Okay. So it sounds like the 1 foot variance with the condition that the existing fence line remain.
Fence and sidewalk, yeah.
Whether they agreed that another fence goes there or not, that's between them, but the existing fence line and sidewalk remain. Is that what we're all in? And then property lines, whatever, is some up to other folks. Is there a can of worms opened, or is that all work? Okay.
Is that a motion?
Is there a motion then?
Sure, I will make that into a motion to approve the variance request of 1 foot on the western property line and to, with the conditions of leaving the existing fence in place and the concrete sidewalk on the eastern property line.
Okay, I have a motion and have a second. Is there any other discussion? All in favor of the motion, say aye and raise your hand. Anyone opposed? That motion passes. All right, good luck.
Chairman, can I be just noted on that one is not participating because I got here late.
Okay, absolutely. Okay, next case.
The next case before you is case 2020-232, located at 3220 A, B, and C Alpine Avenue. They're requesting a variance from the 42.1-foot front contextual setback. They're requesting a 32-foot front setback within the R10 district to construct 2 single-family residences. Is there anyone here in opposition to case 2020-232? Seeing opposition is present, once I go through the slides, you will state your
sir,
case.
if you would keep your mask on all the way, the whole time you're here, please, thank you.
Once we proceed through the slides, you'll have your chance to speak, but make sure that you reserve some time. You'll have a total of 10 minutes for your presenting of your case and your rebuttal to the opposition. This is an aerial view of the parcel. Here's the proposed development on the site. The contextual setback survey provided. Present site and neighboring properties. If you will please go ahead and state your name, address.
Yes, Jody Roberts.
And sir, if you would just push the button right there at the bottom of the mic till the red light turns on. There you go.
Okay. Jody Roberts. The address is 3220 Alpine Avenue. Basically what I'm requesting is a variance from the contextual front setback requirements. Actually, the contextual front setback requirement is 60 feet. I think it states 42 there, okay, but it's 60 feet. By contextual measurements, this puts the front setback at 60 feet on a lot that is 92 feet long on its shortest side. When you factor in the rear setback of 20 feet, this reduces the buildable area to just 10 feet deep on one point and under 40 feet at its deepest point. We are requesting a front setback of 32 feet. The contextual front setback rules generally keep the neighborhood consistent, but in this case, it makes the lot almost unbuildable for a few reasons. The contextual setback requires surveyors to take an average of all properties on the same side of the street and on the same block and use that as their setback. Directly to the right of my lot, 3220 Alpine, is Robert Street. This is an unimproved street that will probably never be improved anytime soon. It's been that way for 20 or 30 years, I believe. Even though it's just a grassy field, it prohibits me from taking the averages of the houses directly to the right of mine. And if you look at 3214 Alpine Park and 2400 Alpine Park, those are two houses just to the right of 3220. Those are at 34.5 feet front setback and 25 feet 7 inches front setback respectively. So in how we got to the 60-foot front setback is it only allows us to take one property, and that's the property that sits directly to the left of mine, and that's 3222 Alpine Avenue. And that property sits on the corner of Alpine Avenue and Alpine Park Avenue. And if you look at it, it's actually the mailbox is on the side of Alpine Park Avenue. So it's basically, it's only allowing me to take that average of that one house. There really isn't a good benchmark based on the strict adherence to the front contextual setback minimums. And looking at the neighborhood as a whole, though, all of the homes running up and down Alpine Avenue and Alpine Park Avenue are anywhere from 20 feet to 35 feet front setback off the street. Our 32 front setback is not conflicting with the character of Alpine Avenue or any of the nearby streets. For that reason, we find it reasonable that we ask for this setback variance. There's a number, the addresses, the lot directly across the street, 3213 Alpine Avenue, has a 30-foot front setback. The house just to the left across the street, 150 feet away from mine, 3205 Alpine Avenue, has 20-foot front setback. So we're keeping within the character of the neighborhood.
And were you going to step these? There's a proposal that we can see on the screen that looks like 42 feet, and then there's one that I think you've put in our packet, and for our board it's page 71, that has one of them in front of, kind of stepped a little bit in front of the other?
Yes.
Is that how you plan to do it?
Yes,
So one will be 32 feet and the other one will be?
Probably about 40 feet.
Okay.
Yes, sir, that's it. That's the proposed. And to your point, what that's going to allow us to do is build a 29-foot wide house by 36 feet deep. It's going to be a big house. It's not going to be a tall and skinny. These will be about 2,000 square feet, only 2 stories. We're not going 3 stories. It'll be 2 stories. Also, I spoke with Council Lady Toombs on Monday and shared with her that we were requesting this front setback, and she 100% supports it 100%.
Yeah,
she said
she sent a letter or an email to us that's in our packet in support.
Oh, did she? Okay, good. She said she was going to do that. So I think, obviously, by granting us this front setback, it'll allow us to build 2 houses, once again, that are 29 feet wide and 36 feet deep.
Okay. Any questions?
I have a question, and maybe I'm missing something here. You could help me out. But it looks like you submitted one site plan where for Unit B, you have a 42.5 foot setback, and then for Unit A, you have a 47. Am I missing that? But it looks like so if that was the case, my question was going to be, why is it not buildable? Why do you need 32?
Well, I messed up. Whenever I originally sent this in, I sent it in as the requirement was 42 feet for the front setback, but the actual requirement is 60 feet. Okay, I made a boo-boo. However, I'm requesting for a 32 foot front setback.
And I understand that.
Yeah.
It looks like at one point you had a site plan where you were able to go 42.5 feet on unit B and
Yeah.
47 feet.
It won't
So
work.
you
It won't
want-
work to allow us to build a little wider and deeper. We need to be at 32 feet.
It'll allow you to get more square footage on the houses.
Yeah, a little bit more square footage, and it'll prevent us from building the taller, skinny houses.
These don't look like tall skinnies on this site plan you submitted.
Yeah. Right, but I think we might have infringed on that 20-foot setback, and I'm not looking at the one you're looking at, and also it might prevent us from some views.
It's what?
It may prevent us, we wanted to offset the houses in a way that will allow us to, have a deck on the, not a rooftop deck, but deck off the second level of the house to have views, so it allows us, because that lot is irregularly shaped, it's not square.
Right, I got you there. But, I mean, in one sense, wouldn't it look more aesthetically better if the front of the houses line up with the same front setback?
I see houses all the time with an off setback, and plus you want the neighbors want a little bit of privacy. I mean, these houses are 6 feet or 8 feet apart from each other, so it's always good to kind of offset it to have more privacy where they're not, walking in the door together, kind of similar. And plus the lot's just irregular. It's challenging to do that, to put them side by side, because you can see on the right side, on the left side it goes straight up, but on the right side it kind of prevents that. But it just, yeah, I mean, I would rather have it offset personally.
Okay, thank you.
Any other questions for the applicant? Did you have anything else to add?
No, sir.
Okay, we'll close the public hearing. Oh, I'm sorry, there's opposition present. So we'll hear from the opposition, and the applicant will have 6 minutes and 30-something seconds to.
Could I add something real quick?
Yeah, if you want to now, or you can.
I was just going to make sure I made it clear, because on that one that you have, the 42, my surveyor messed up. That the houses won't quite fit with the rear
How did he
setback.
mess up? I'm trying to figure that out. I mean, it looks like somebody drew out site plans for Unit A and Unit B, and one with a 42-foot front setback and one with a 47, so how did he mess up?
Right, the side setbacks and the rear setbacks, it just doesn't work out.
Well, it looks like he considered both sides.
He used properties beyond Robert Street on the right.
So you're saying that this is not correct because it doesn't have a 10-foot setback, even though it says it does?
Mr. Pfeffer,
Yeah, I don't have the same. Is
I
that it
think
right
what
there?
I think,
Yeah, go
and if
ahead.
you can tell me that this is correct or not, but what he's saying is that they calculated the contextual street setback wrong for this plan that he created with the 42-foot. It should have been a 60-foot contextual setback based on the houses that applied, and maybe staff
That's
can
right.
speak to that too. And then but he doesn't have one that shows what they could do if it was a 60-foot, which is what it actually is required to be based on the contextual.
Yeah, and I get that part. It just looks to me like at some point, and I think maybe what you're saying is he got the boundary line wrong, so even though it says, I wasn't trying to be a smart aleck with you.
Right,
Are
sure.
you saying that there's a 10-foot, that there's really not a 10-foot setback because the boundary line is improper or was not calculated correctly?
Right, I just know he had shared with me that wouldn't work after he sent it, and I apologize not knowing exactly why. But he goes, Jody, the 42 isn't going to work. You need to make sure you request 32 feet.
Okay.
Okay, so you will have 6 minutes and 6.5 minutes-ish for rebuttal, which Jessica will put up when you get back. And in the meantime, we will hear from the opposition. Who all is opposed to this? All right, so you'll have, sir, if you would just take a seat. Yeah, you're done for now. Take a seat. And the opposition can come up, if you would, if you're in the same household, you can sit at the same table, otherwise come up one at a time, but you all have 10 minutes total to express your views. And somebody needs to come up. Yeah. All right, so if you would state your name and address and tell us your thoughts on this case.
My name is Francine Johnson, address 3222 Alpine Park Avenue, for over 45 years. I would like to take an opportunity to read my feelings. Good afternoon. We are Mr. and Mrs. Jimmy and Francine Johnson. Thank you for your service to this board. We recognize you are volunteers and we appreciate your taking the time to address these important issues for our community. We own the property at 3222 Alpine Park Avenue. We are here in opposition to this variance application and would like to respectfully ask the Board of Zoning Appeals to deny the variance that has been requested. We would like to tell you why. Under Metro Code of Laws, Section 1740-180B, the board has the power to decide whether a person should have to comply with the law the zoning code has written. It is deemed so. You have the authority to allow someone to vary from their law and hereby grant a variance of zoning code. But the authority has certain requirements that must be in order to grant the variance. Under the review standards in Metro Code of Law, Section 1740-370, in order to grant the variance, you must be able to say that you find hardship related to the land, that you find that the characteristics are unique, that you find the hardship is not self-imposed, that you find financial gain isn't the only reason to grant the variance, that you find there would be no injury to other properties in our neighborhood, and that you find the granting of the variance would not hurt the public welfare and not impair the purpose of the zoning code. We ask you to deny the variance request because the applicant does not meet all of the conditions above to support the findings required. First, in order to get a variance, the applicant must show hardship. There is no hardship here related to the physical features. It is our understanding that the applicant is asking for a reduction in required setbacks so he can build more than one house. He would like to build two houses. He does not have enough room to build two houses. Perhaps if he only builds one, perhaps he could configure such that he would not need to reduce the setback. In this case, the applicant does not have an undue hardship. Next, in order to obtain a variance, the applicant has to show unique characteristics not prevalent to the properties in the general area. In this case, as we understand it, there is nothing unique. It appears he is trying to create a unique situation by placing houses closer than the law allows, and that brings us to the next requirement. The board is not to grant a variance if the hardship is self-imposed. And looking at the Metropolitan Code of Laws, Section 1740-370C, self-imposed is identified in the code as a difficulty that has been created by the previous actions of any person of having an interest in the property after the effective date of the ordinance codified in this title. This means that if he is responsible for the situation in which he finds himself, he does not get a variance to receive himself of that situation. Here we believe if there's a hardship, it is self-imposed due to, 1, his desire to build two houses on one lot, and 2, his prior seeking of purchase of a lot is not just big enough to do what he wants to do with it. The lot was subdivided to the current size. It was not always this size. If there is a hardship, which we would assert is not, but if there is, it is self-imposed. Additionally, the board is to not grant, a variance solely for financial gain. Here it seems that is the sole reason we are here. If the applicant builds one house, he can sell it for one amount of money. If, however, he builds two, it stands to reason that he doubles his profit. Respectfully, it's pretty much that straightforward. Under the code, the board is not to grant variance unless the applicant can show that there is no injury to the neighborhood property. Simply put, it appears that, to us, that the applicant has provided no evidence that he proposes will not hurt our property values. It seems under the code, this is his burden to meet, and we do not see where he has met it. To the contrary, we believe it will be actually have a negative effect on our property. Additionally, we have spoken with a neighbor that may directly be impacted by potential water runoff. There has been no evidence to address how these aspects could be mitigated. Next, this board would have to show there is no harm to the public welfare and would not substantially impair the intent and purpose of this zoning code. Here, the harm to public welfare is the impairment of the zoning code. This code protects our community welfare and is referenced on today's agenda in a contextual setback. This means it is set based on the context of the neighborhood. To grant this variance, it's completely undermined the purpose and intent of having a contextual setback. The applicant is creating a checkerboard pattern of development. Our property is considered in determining the contextual setback. To grant this variance would mean you would disregard our property as context. We will not address the integrity of the master development plan, but the fact that the applicant has to meet all the above and reason enough to deny the variance. We recognize the board has an important task. We hope and pray that you will have that we have provided information that is helpful to you. We respectfully ask that this variance request be denied. Thank you for your time and attention.
Okay, ma'am, I have a question for you. You said that the lot had been divided. When did that happen?
Well, we've been up here, like we said, 45 years. We are probably the last of the, I call us the old heads. And the house next to us, that has always been that particular neighbor's front yard. So I think Mr. Robertson, they decided that he would sell him, told us, his front yard. And in doing so, they're not going to be able to build them in line with our house because it's always been a front yard. And when he wants to say about the, up there is still a lot of undeveloped lots. Like when he spoke of the Robert Street, next to that is a big vacant lot. Across the street is a vacant lot in a house where the neighbor who may have the potential water runoff, she's across the street, but next to her, on both sides of her, are vacant lots. And typically, a lot of the neighbors, in the area, they're not homeowners. We are the last of the homeowners. A lot of them are renters. So we're the only one that really kind of has like a stakeholder in what's going on and keeping everything uniform. That whole area was a beautiful section, and now a lot of the developers who are able to get in, they're making it look totally different. So,
ma'am, so I appreciate you all coming here.
Yes.
So you're saying that this was subdivided from the lot that's kind of up the hill from it? Is that is that correct?
Right.
Okay. And what would your relation to this be? How are you?
Well, unfortunately, I don't have.
Okay,
but I do have pictures.
Not immediately. Are you immediately adjacent? I guess is what.
Lisa, will you show the overview?
Pardon me?
Okay. I'm sorry. Yeah. So I think they're in 3222, right?
Right.
Is that what you said?
So we're down here, and that other house is back up here, and that was his front yard, which we have a deeper backyard. He had a deeper front yard.
So you're on the corner of Alpine and Alpine Park there. You're that house on the left side of it? Okay, cool, thank you.
And so it's the 3220 whose
Is the
lot
house-
got divided into two, and now they're wanting to build two houses in the front.
And they're not gonna be in line with our house. They wanna make it offset, so that doesn't lead into the characteristics of the neighborhood to be uniformed.
It's gonna be even more, it's gonna be even more because where my driveway goes up, there's 2 feet that goes over that, on the other side of that property line. And if he just adds 5 more feet to that, it's gonna make it even narrower.
Just for the record, would you introduce yourself? I don't know if you...
I'm sorry. My name is Jimmy Johnson,
Okay.
3222 Alpine.
And then who lives at 3220? Is that neighbor still there? And
His neighbor's still there. Mhm.
and they sold part of their lot.
Right.
But they're not the developers. They sold that.
The front part of his lot to Mr.
You need to push your button.
He sold the front part of his property to Mr. Roberts. As you can see, a little history of this, there's one family home, they were named Phelps. Many years ago, they split up that whole section right there. The son built the house where we live, where our house, 3222. And then there was a back part. He sold his back part to someone else, which we bought after we moved up there. Then Mr. Cullen, being the third owner since we've been there, sold his front part to Mr. Roberts. And as it goes into a pie wedge there, and it gets narrower as you get to the front, it's even that much more. My front is 320 feet, but this down here is about only maybe 75 feet.
Okay. Any other questions at this point? All right. Did you all have anything else to add? I know there's another neighbor, and there's not a whole lot of time left for that neighbor or another person. I assume they're a neighbor. Unless you all had something else you wanted to say, but.
That we would just like for the characteristics of the neighborhood, the contextual overlay, to be as even and conformed as possible. Because if you're gonna have a house here, a house there, and a house there, and a house there, that's not conformity. And it does make the neighborhood not look
I
in
don't think
a
they can
aesthetic
move
way.
back any further because there's light or electric wires that run across that property, even to the back of my property.
Okay. All right. Thank you, ma'am. If you would come up and when they have a chance to leave and state your name and address and your thoughts on this case. And just remember to hit the red button or hit the button to turn the red light on.
My name is Kelly Zumwalt. My address is 3213 Alpine Avenue. And if you see up on the picture there, 3220 is Michael, 3222 is the Johnsons. The red dot is where the proposed buildings are. I live directly across the street from the red dot. My dad always raised me to try to work it out with your neighbors, but get it in writing. So that's why I'm here today, is just to be on record that we have some concerns and address those. I have spoken now to the builders, and I think that I'm pretty confident that we can work some things out.
Can you speak into that microphone, ma'am?
I'm sorry?
Can you speak into the microphone a little bit more? You're a little bit muffled.
Your mask is totally covered. Mask. There, you're perfect.
Was fogging up my glasses. I couldn't see my notes. I have 4 concerns. One of them is that we have quite a few other builders in the area right now. There's no master plan. Each section, each new building is completely different from any other. So there's no unified even vision of where the neighborhood is going or what it's going to look like. It looks really tacky, to be honest. We have had other builders in the area coming onto other people's yards and doing work there. I think that Johnson's, for example, had a tree that a builder who's building up in the far corner there came on their property and chopped down a tree that is outside of his scope. My other concern is the drainage. You can see that, well, that whole hill basically leads straight down into my house. There's a culvert right now that runs on that side of the street, and it collects all the rainwater and takes it away from my house. My concern is that there's a 21-foot driveway proposed in the new building, and that's going to leave a 21-foot river heading straight towards my house. But we have discussed maybe adding a French drain in that area to take care of that. So if that can be put on the plans, that would address that. I'm also concerned that these plans do not effectively or accurately show what work is proposed. The numbers are not right, the setbacks are not right. I would like to see that changed officially before the board goes ahead and decides whether or not the variance can be addressed. And the last thing I want to address is that we have, in the round part at the top of the hill, there is a house up there where there are numerous drug activities that take place. You can see on the bottom of that picture, the road curves like this, and there's a sharp corner with bushes on both sides. I have 11 kids. I think the people up the road from us have about 8 kids just at the corner, so that's a lot of kids in the area. We have cars that come up and around that corner really fast. I think we need to address that before we add another couple of houses there in their driveway and their construction materials for the next 9 months,
Okay.
Whether that's a speed bump or a light or something.
Okay, any questions for this person?
Thank you.
Great, and how long have you lived in the neighborhood?
We've been there 2.5 years now.
Okay, awesome, thank you.
I would also like to say that these buildings are going to block all of our view, and I realize that times change and you got to move on. But one of the reasons we bought the house, and I think the Johnsons, is that we have excellent views of the entire city of Nashville. And building these houses is going to block all of our views. So I'm sure that's something we're considering.
Great, thank you. All right, we'll hear back from the applicant who has 6 minutes, I think, and some change. I'm sorry, was there more, is there somebody else? Yeah, I mean, we're out of time, so unless there's a specific question, or if someone, I don't see anybody raising their hand to speak, but if they did, we could address that, but there's no one. All right, so sir, you have 6 minutes and 30 seconds for rebuttal.
Okay, great. They are incorrect. The house that's above me, the Michael Cullen house, that address is 3220 Alpine Park Boulevard. We purchased from him 3220 Alpine Avenue.
What is A, B, and C?
Oh, that's just, we've already got the HPR documents. That's the horizontal property.
Oh, so the C's the common.
Yeah, the common.
All right. So the A and B, and then the C's common, all right.
Yes, sir. So we're not, and this is a very unique situation, in my opinion, when you can only take one house on that whole side of the street, and it's the house to the left of us, and it's a corner house. And quite frankly, if you look at the house, it's got a driveway on Alpine Park Avenue, and it's got a mailbox on Alpine Park Avenue, the Johnson's house. So quite frankly, it looks to me that that should have an Alpine Park Avenue address, and it's only 20 feet.
Does it have an Alpine Park Avenue address?
Let me see.
I mean,
no, it's got an Alpine Avenue.
I mean, when you look at it from the front, it looks like it faces Alpine Avenue. I'd see that it's accessed by Alpine Park.
Right, and it's got a mailbox on Alpine Park.
It also has a driveway on Alpine too.
All right.
Yeah, but my point is, it is very unique in that we're not doing anything. This parcel, it's over 10,000 square feet. It's a little over 13,000 square feet. We're not increasing the density by any means. By right, we can build 2 houses. It's just unfortunate that the one house in this whole area has a 66-foot front setback. If you look at every other house, and I can pass this around to you, there's not another house on Alpine Avenue or Alpine Park Avenue that has over a 40-foot front setback. And we're just asking for 32. Kelly, the lady that just came up and spoke, she's directly across the street from my property, and her front setback is 20 feet, directly across from my property. The two houses down to the right are 30, let me get my notes here, excuse me. The two that are down to the right, which I would be able, keep in mind this, that Robert Street right there, that's an unimproved street. It's a grass strip. There's not even a pavement or anything there. If that unimproved street was not there, which it's not been a street for, I think, 30 years, if it was not there, I would be able to take the averages of the two houses to the right of my house. And once again, those two houses, one is at 34.5 feet, and the other one is at 25.7 feet. And as far as me having here's the schedule, the one that you have with the 32 front setback for the left house, and then I think 37 for the right house, that is real. This is surveyed. Those are the real dimensions.
Yeah, I guess and I don't know where, I see where you got 60 and our packet says 42, but, when you take the 60 feet that the 3222 is and the two numbers you just mentioned and you divide them by 3, which is the 3 houses next to you, you get around 42. So it sounds like those may have been considered to get to you 42. So, I don't know. I'm just saying, but I guess what I'm looking at is back to Ross's question, Mr. Pepper, of, if 42 is the average of the 3 to provide context, and you've got a site plan that seems to have the same size homes on it, it seems like it's a view issue, not a I can do it issue.
No, a view issue, well, it's part of, a view issue, I could go up 3 levels. I'm not doing that. I'm just going 2 stories. I could attach these houses, attach these two, periodically, and it would allow me to go higher. I'm not going to do that. I don't like attached units. Most buyers don't like it. I could attach them and go 3 levels and go 36 feet probably. And then I'm blocking their view and the one across the street from me. Instead, I just, want to build a nice size house, width and wise, keep within the, I don't think I'm doing anything that's not keeping within the character of the community.
Okay.
My question to you is the Johnsons were there when you bought this property, correct?
Yes. I don't know if they live in the house, though, actually.
Okay. Well, their testimony was that they live at. I'm going to assume that what they said was the truth. Right. And their house was there, and the topography hasn't changed any since you bought this property, has it?
No, sir.
Okay. So their house was there. The house up at 3220 was there, correct?
Yes, sir. Sure.
Okay. Did you do any preliminary work to understand what you could or couldn't do before you purchased this? Or did you buy it just to develop it?
Well, no, I did do preliminary work.
Before you bought it or after you bought it?
No, before I bought it.
Okay, so you knew that this problem was already there?
Well, no, the one thing that we didn't know, okay, was Robert Street. Okay,
So you didn't do the full investigation before you bought it?
I went to water sewer, made sure there weren't any encumbrances. I looked at the averages.
No, I understand you're going a long way around answering the question, and it's a simple question. You didn't do all of the necessary...
No, sir.
Okay.
I didn't.
I've got no further questions.
Any other questions for the applicant at this point? Okay, sir, if you have 33 seconds.
Okay. Yeah, I'm just simply asking, I shared this with Council Lady Toombs in our district, She is 100% in support of it. She goes, Jody, I think that this will keep within the character of the neighborhood. I know you're doing other buildings over there. I like what you're doing. I think it will fit well in there. And you've thoroughly described it to me that the front setback, she goes, I see no problem with it. All the averages of the other houses are right around 30 to 35 feet. She had no problem with it.
Okay. Any other questions? All right. Thank you. We will close the public hearing. We do have a letter from the council lady in our packet supporting the project. And it's just a generic request to ask for its approval. And then there are a couple of letters of support from folks who have addresses on Alpine Avenue also. At least, well, 3 of them say they're on Alpine, and 1 of them doesn't have an address listed. So at least 3 of them are in the area of Alpine in support. And obviously we have the neighbors that came today that were opposed to it. But that's all the summary of all the feedback we have.
Well, I don't have any reason to doubt the survey that's been stamped by a surveyor that allows a 42.1 contextual street setback, and it takes into account the Johnson's house next door, and then those 2 that the appellant referenced that were 34 feet and 25 feet away from Alpine Avenue. So I don't have any reason to doubt that that was taken into consideration and that he's allowed a 42-foot front setback. And I'm not inclined to, I don't see a hardship to allow a 32-foot setback. And so I'm not inclined to support the request.
And I agree with Ms. Carpenet. I'm not inclined to support it either because I don't see a hardship.
Yeah, I definitely see an irregular shaped lot, but I do see some injury to the neighbors to allow that. And at 60 foot, yeah, it's a pretty unbuildable lot. That's pretty tough. But even at 50 foot, he could build 1 house there and build a really nice house. I could probably be convinced of less than 50 feet, but that was I thought that's kind of right in the middle of at least where that original calculation was and what is required. And because I do understand also that I think to say that there's an established development pattern on this street is a stretch because there's a lot of open land, So, I understand. I think that there's room for some kind of variance, and it's a regular shaped lot. But I don't know if I would agree with going all the way to 42. But I could probably be convinced.
You mean to 32?
Yeah, definitely not to 32. I don't think.
I think though. I'm still confused. I know he said that it's 60 because of that unimproved street, but like I said, the survey says 42, and I don't know do we know?
With some apology for cutting through the knot rather than untying it, the real question is, does it get 32, which is what's asked. So think of it that way, regardless of whether it's a matter of the contextual street setback is codified at 1712-030 Part C, Part 3, or the chart for the street setbacks, which would be 20 foot for a minor and local street in an R10 zoning district multiplied by 3 if you're looking at it from the contextual analysis. Regardless of what that number is, his ask is the same. So just think of it from that point forward maybe in analyzing, and you can get to, unless it is in your minds, kind of a function of, but by percentage, or is it a small ask or a big ask?
No, I mean, what I was really thinking was that if it's truly 42 and he shows 2 units with a 42-foot setback, he can do what he wants to do by right, and he doesn't need a variance, and therefore, if we don't believe there's a hardship, we can deny the variance. But if it's 60, like he says, then, even, we heard that 50 would be a buildable lot, then I'm not sure if we don't see a hardship that I would want to say, oh, you can have a 42-inch or 42-foot setback, when it really might be something different. So that's where I was just wondering. But like I said, the three, I don't know, the three properties that we know are close or neighboring on either side, the ones that he mentioned, when you add those up and divide by 3, you get, I think, 42, 43. And so that seems to suggest that 42.6 as the setback is accurate.
Is in that ballpark. And Mr. Chairman, I think of course you always know, but for our newer board members, that can be part of your analysis. Because ultimately, when you're looking at the question of, do we see a hardship represented here by the shape of the lot, the topography of the lot, the orientation and curvature of the street, you could look at this and say, but for that closed street, Robert Street, unimproved and no longer used, this would be a matter that potentially dragged in those other houses, and therefore it functions as though all of them play into that 42.6-foot analysis. If that's the case, then that certainly colors your determination on the request, I could see. But that can be part of what you consider in looking to see, is this yet another element that constitutes a hardship? And if so, then it's probably worthy to consider what you think about those other houses that make it down to 42 rather than 60.
I think if he has a 60-foot setback, then there is a hardship, because I don't see how that's a buildable lot. So that's why that's important to me.
I mean, that's not what our packet said. It said that 42 was required, and he's asking for 32. So I think the request is he wants 32. Do we think has the evidence shown a hardship to warrant 32? I haven't seen any evidence to warrant that request. The 42, he didn't argue necessarily. That's what he argued was the hardship, not necessarily the 60, and that's kind of what our packet said. So I thought what you initially kind of said, that's why I agreed with you, just because I understand the discussion, but I was just, and I don't know if what I just said was helpful or not, but it seemed from reading the packet that what's required is 42, and he's asking for a 10-foot variance.
Yeah, I agree, but if we don't know what he's actually allowed, and then let's say we deny it, and then we all think he's allowed the 42, but he's actually restricted to the 60, I don't think he can build with the 60.
But we're being asked to interpret his request, and I think that's outside of our function, and I'm going to make a motion, Mr. Chairman, that we deny the 32-foot request. If he wants to come back and ask for something else and can present the evidence, so be it. But the request is the request. That was the reason I asked the questions at the outset. He knew what he was getting into, and I guess I'm being the bad guy today, but
Well, I don't think it's being bad. I think we're all, I'm having a tough time with the 32, and I think that just trying to anticipate a little bit, and only because he came today with information that was not in our packet and was not part of the formal request, saying he thought it was 60, and is there a way to and maybe, so you made a motion. And
I made a motion.
I'll second if you'll allow the condition that if it's determined that his setback is 50 feet or more, that he be allowed to bring back a proposal sooner than the 6 months delay. And so if his setback is determined at 42 like it's presented, he can build just like he's diagrammed it.
I don't have any problem with that. I just, when they come to us, I'd kind of like them to know what they're asking.
I just want to give him a path. If it's what he said it was coming here, if it's what he presented and what he asked, then I agree with you. So that motion seconded with that condition. And is there any other discussion on that motion?
Well, this is not really discussion, but I'm going to vote in favor of the motion. But just so I understand, so I'm going to jump ahead next time. And it's hard for me to understand because everybody, the muffling. So it is, what we know today is that it is a 60-foot contextual setback. We're accepting that.
No.
We're not.
We're not, because he, in his proposal and his survey, it says there's a 42 foot contextual survey or setback. In his application, it says it's 42. In his presentation in person today, he said that was a mistake and it was 60. And so
So the required setback is not 60, it's 42?
Well, we don't know, and that's
Okay,
what we asked.
I was talking about the required setback,
Yeah,
not
that's what we
he's-
don't, that's what we don't know. Now, if you take the property that the neighbors who came today live at and the two others, like you're looking at the screen right now, if you take those three properties and divide them by, their setbacks by 3, then you get around 42 feet. So it makes sense that 42 might actually be the contextual setback.
Right.
But there's still some question there. And so the motion is to deny the 32, and if he can build at 42, but if he's correct and it's 60 feet, then he can, bring us some evidence of that and come sooner than waiting 6 months.
Okay, that helps.
Because to me, everything points to 42 being logical, and it may be correct, but then he may be right too because of that street and saying, well, no, it's really 60, and we don't have that answer now.
Right, but Metro's position coming into this was it was 60 feet.
No, I thought it was,
No, in the
I
packet,
picked
I think
up
the only person we've heard 60 from is him, and we haven't had it confirmed by anybody, but he originally, when he applied, said it was 42.
Okay,
That's where the confusion is.
okay, that's what.
And I don't doubt him necessarily, but we don't have anybody saying exactly what it is. And what we're saying is, you've shown us like you pointed out when we first saw the case, there's a drawing in our packet on page 70 that shows 2 homes at 42 feet. And so if it comes out 42 feet, he's shown he can do 2.
Gotcha, okay, thank you.
So there's a motion, there's a second.
Call the question.
No other discussion? Then all in favor of the motion, say aye, raise your hand. Any opposed? That motion passes. Nick?
The next case is case 2020-235, located at 1101 McKinney Avenue, requesting a variance from the landscape buffer requirements within the MUGA district to construct a restaurant. The rear setback determination in the original variance request will be made by the Historic Commission. Also note that the urban forester is in support of this variance request for the landscape buffer variance. Parcel viewer, is there anyone here in opposition to this case, the case 2020-235? There's no opposition, so I'll go through the slides and the appellant then can come forward. Here's the overhead aerial view of the property. Here's the proposed development. Existing structure, alternative view, and intersection. The appellant would go ahead and state your name and address.
Jay Fulmer, 2002 Richard Jones Road. No, thank you, members of the board, for hearing us today. We've got a pretty neat project, and the site plan, I'm pretty intimate with it, so it makes more sense to me than it might to y'all if you haven't seen it a whole lot. But the existing car wash on this lot it's been there for a long time, and I've got a very visionary client with a pretty neat idea, and it's to take each of the car wash bays and turn them into small kitchens. And it's intended to be a restaurant incubator. And so there'll be no seating inside, but it allows chefs to rent each space with a different concept and help get their concept off the ground. So it's kind of like a fixed food truck location, and then once they get up and going, they can go and open a brick and mortar, or they can go get a food truck or something of that nature. And they've already got a lot of interest in this. And so what spurred the application, which I filed incorrectly, which is what Lisa was talking about at the beginning, is we're adding walk-in coolers to the rear. And so there's a 20-foot rear setback that the existing structure sticks into by about 1.5 feet. And so this would be a further setback encroachment. What I didn't realize is setback encroachments for this parcel go to historic. And so that's no longer part of the application that's being presented to you. That'll be decided by historic. But there's also a landscape buffer because this small site is zoned MUG, which, you know, is one of the most intensive mixed-use districts. And so it abuts a residentially zoned property. And the residential property owner is in support of this project. We've been trying to get confirmation from him in writing. He's verbally been supportive, you know, for several months, but we didn't get that. Brett Withers is also supportive of the project. Today, it's a sea of asphalt, you know, but with the amount of investment we're putting into the building, I don't want to call it a continuation of nonconformity. What we really want to do is a reduction in landscape buffer because we want to put something up to separate the residential property from our property. And there's a small retaining wall in the back. What we're envisioning is, you know, a fence with vines or, you know, something of that nature that provides a landscape screening. But we have to do it in a very narrow nature because we really only have the top of the wall to work with. So what I'm hoping to ask from the board is to approve for us to work with the urban forester, you know, to come to a good agreement. And I've told the urban forester that we'll be happy to work with him, and that's why he recommended approval.
Okay.
So you're gonna work with the urban forester to see what kind of vegetation you can work in with the screening fence, is that?
Right, so out there today, there's a few foot retaining wall. And what we can do, there's a fence on part of it right now. We want to supplement that. We don't know if the neighbor, we want to obviously have the neighbor weigh in a lot on it, but we don't necessarily want to put just a solid wood fence unless that's what he wants. You know, I think it'd be neat to do if you do one of those vinyl coated chain link fences and grow a vine in it, you don't even know the chain link's there. It really disappears. But that could be a really neat landscape buffering that would also help with a little noise reduction. So we've got some ideas, and if y'all are comfortable with us working through that with Stefan, then I think that'd be the easiest way for us to have a good product on the end.
Okay. Any questions?
So what's the actual reduction?
In footage, it would go down to something that really lines the property line. So we haven't put a foot to it, but if we need to put a foot to it, then we can.
I'm just a little uncomfortable approving variances without specifics.
What's required?
10 feet.
And this property is a weird property too, because if you look at it, you think it fronts Gallatin Road, but it has a McKinney Avenue address. And so when we were looking at it, when we thought the setback was part of it, which I know is not on the table today, it goes to historic, but it's like, well, what is the front and what's the rear? And, and I think that, but we're really talking on this bottom right picture that what goes between the existing space and that home to the right.
So the front is on Gallatin.
Right, but it has a McKinney Avenue address is what I'm saying.
Right. And we're not changing the footprint of it, and so we could respect front setbacks.
But the buffer area is between, go back to that other picture, I'm sorry, Lisa. The buffer area we're talking about is between that red brick building and the white home on the right.
Correct.
That's the area that's at play with the buffer.
Correct. And that's where we have a sidewalk that walks behind the walk-in coolers to get to the backs of these units. And then the walk-in cooler also occupies part of that area. And I think, correct me if I'm wrong, but I believe we filed the application for a waiver of the buffer altogether, and that's what the urban forester supported. But we want to put something there, and so that's why I was calling it a reduction.
Okay.
I'm not sure if that can be considered.
I don't know if that helped at all. I know your fundamental point I get because and it's
no,
true,
but he answered the question.
All right. Any other questions? Did you have anything else to add?
I'm happy to answer any questions, but that's really it.
Okay, then we'll close public hearing. I think that they had said that the applicant is asking, I believe, for a motion that says to allow them to work with the urban forester to agree on an acceptable alternative buffer, landscape buffer for this property, which
Well,
seemed,
I guess it would be more an alternative to the landscape buffer. Is that
Right.
correct? Yeah.
is that, any thoughts?
Well, I would, I mean, I thought my understanding was they would work with the urban forester to, I understand they want to put in the screening fence, but that they would also work with the urban forester to try to get some kind of vegetation in there. They obviously can't put 10 feet because they've got 7 feet and they've got these coolers that'll be sticking out. But I do think something in addition to the screening fence could go in. I don't know how much, and I think that would probably be up to the applicant and the urban forester to talk about.
So did anyone have thoughts or, I'm sorry, Ashanti?
I mean, I realize that this is like a cool idea and that it's a way to renovate, like repurpose a space that people are inclined to like. I just think that, so I'm familiar with this area and this abuts right into residential areas. So the reason why we ask for this type of buffers is to have a transition between the commercial activity into a neighborhood. And I realize that there's a fence and there's a sidewalk. I just think that a flat-out waiver of some sort of landscape buffer before you hop into a residential neighborhood, it just seems sort of aggressive. But I'm still listening, and I think that there's probably sort of a way to solve for this that I probably haven't thought about.
So
I agree with you, and I think there needs, if there can be a landscape buffer, I'd like there to be one, even though it can't be 10 feet. I'm with you. I don't know what can be done and what can't be done. So I don't know exactly what the solution to that is.
I've got a question for the applicant, but I couldn't remember if the public hearing was still open.
It is, but we can open the public hearing for a question. With no objection.
So I'm trying to remember what I read. Was it a landscape buffer C that was required?
Yes, and so for it to be 10 feet, it has to have a masonry wall plus 10 feet of plantings.
Okay, so a wall is a component of it. So your proposal is to build some kind of wall, just not have the 10-foot buffer part.
We want to add fencing on top of the existing wall instead of trying to demolish it because it is right on the property line. And so to get the wall in with the footings and whatnot, we're very limited with the way that the coolers project out plus the walkable path. And we have to get people into the back of the kitchens. And today it's 100% paved, which is, so it kind of falls in that gray area. Is it an existing non-conforming that we're altering, or is it a variance from a buffer requirement for a new project? But
your request is to do part of the landscape buffer in terms of a wall, and it may not be a masonry wall, but it will be a wall.
Correct.
And so your request is to do a partial landscape buffer, to do the wall part, and it may not be masonry, and to omit the 10 feet of other buffer.
Correct.
Okay.
Can I keep it open? I want to
Sure.
ask another question of the applicant. So was there any idea about readjusting how the coolers were put so that it would give you the additional space? I'm trying to find your hardship.
Functionally, in the back of each of these bays, there's room for a door and room for the cooler. And so the cooler has to have a minimum shape for the operation to be functional.
I mean, you couldn't, instead of having it going, say, north-south, you couldn't have it cocked at an angle or going east-west. Okay, good. So you've already looked into that side of it.
Yes, sir.
Very good. Thank you. Thank you, Mr. Chairman.
All right, any other questions? We'll reclose the public hearing. I guess at this point, probably should throw out a motion and then perfect it for the concerns that people have. And it, you know, I hope that the goal is met, that there is a buffer that's more than just a waiver, because I agree that the waiver is not itself just probably not a good solution. And I don't really mind the applicant working with the urban forester to come up with an alternative solution, but I really want to make sure that the language is acceptable to folks, so that it's greener than it is now, but not as green as the code would require if it were an empty lot. And so I'll throw out that we'll make a motion that we approve the landscape buffer variance request on the condition that the applicant work with the urban forester to agree to an acceptable alternative landscape buffer, which is acceptable to both parties and the adjacent homeowner. And we'll ask the board if there are additional aspects that need to be stated to fill in the blanks.
So as I understand it, the agreement of the adjacent landowner is a mandatory requirement too. So, I mean, you just can't say, well, this looks nice.
Yeah, and I think they came to the board with the adjacent landowner's support of the concept, and I think that just having that person's approval is important. If it shouldn't be a controversial. It sounds like they may have already talked through a solution that's acceptable to all three, and if that's the case, then they're in good shape. But if it's not, then they need to continue to work it out.
Can I ask for clarification? Is that possible?
You're the chairman. You're getting paid the big bucks for that.
Yeah.
We have no problem with that, but in the event that the two parties somewhat start disagreeing for whatever reason, times change, is it possible for us to come back to you guys prior to 6 months?
Yes, yeah, that would be part of it too. Yeah, absolutely. And I would, frankly, I would expect it to be a continuation of. Well, I don't know if we can do that. Yes, you can. That would be a clarification or an amendment that should an agreement not be met, that the applicant can resubmit this for further discussion with this board at that time. Is there any other? Does that meet some of the concerns that you had, or?
Yeah, I think that's a nice compromise. It sounds like as long as there's some sort of buffering going in place, I don't know what exactly that is, but I think with the requirement that he works with urban forester and he works with the other party, I think that addresses everything. And then he can also come back sooner. I think that sort of puts all the rails in place.
I'm happy to support something a little more, even more aggressive if you all have language to do it, but I think that is at least the starting.
I'll second that multifaceted motion.
Okay, I have a motion and a second. Is there any other discussion or thoughts on an amendment? Seeing none, all in favor say aye. Any opposed? That motion passes. Good luck.
Thank you all.
Last case.
The next case for the board to consider is case 2020-223, located at 5476 Old Hickory Boulevard. It's an item A appeal challenging the zoning administrator's denial of a short-term rental permit. The appellant operated after the issued short-term rental permit expired in an AR2A district. At this point, Mr. McBroom is here on behalf of Codes to make a presentation. Is there anyone here in opposition to case 2020-223? Seeing none, Mr. McBroom will state the facts.
Good afternoon, Board. On January the 1st, 2017, the listing was first posted. On August the 2nd of 2017, the listing was identified by host compliance. On October 27th, 2017, host cease and desist letter was sent. On 11/3 of 2017, the estimated delivery of the letter and no documented stays after the letter was received. 11/11 of 2017, the advertisement was removed. 30 documented stays prior to obtaining a STR permit from January to October of 2017. 11/17 of 2017, the first BZA appeal was filed for advertising operating before obtaining a short-term rental permit. On 1/4 of 2018, the BZA appeal hearing result was BZA upheld the zoning administrator and appellant able to apply for a permit on January 5th, 2018. On April the 4th of 2018, the permit application was submitted. On April the 13th of 2018, the owner-occupied STRP permit was issued. On March the 18th of 2019, the permit was renewed. On April 13th of 2020, the permit expired. On 9/15 of 2020, the advertisement was removed. On 9/21 of 2020, the BZA appeal was filed for advertising and operating with an expired permit. There were 2 documented stays after the permit expiration, no documented stays after the appeal was filed, and there were no documented complaints against the property.
Did you say there were stays after the appeal was filed or no?
None.
None, okay. All right, if you would state your name and address and tell us what happened with not renewing your permit.
Okay, Susan Shan, 5476 Old Hickory Boulevard, Ashland City, Tennessee. And I'm within the border of Davidson County, obviously, that's why I'm here. So I received the letter saying that my permit was expired and I should discontinue advertising, and I did that immediately, but I do not recall, and I submitted an email just basically saying, I don't recall receiving any notice that the permit was due to expire, and it just, you know, we're all busy. It's not in the front of my mind that my short-term rental permit, also, we were in the midst of COVID. If something was sent, is it standard for a notification to be sent when your permit is due to expire? Because I certainly would have addressed it immediately, but I don't think I received anything.
Well, I know that the codes department does send out letters, and we do have folks like you that come and say, I didn't get the letter, and we have no reason to doubt that you didn't get the letter because that happens. But I know the codes department does send out letters.
Okay.
Renewal letters.
It's possible a letter was sent and overlooked, but that would surprise me. I checked the mail pretty thoroughly. What I think, and this is purely theory, I have no way to prove that, but due to COVID, I think a lot of people were not operating in their offices, and it might have been an oversight. In any case, wherever the oversight occurred, I believe it was an oversight. I just failed to pay it, and I'd be happy to do that, but I didn't realize it had expired until I received the letter, and then I took the necessary steps to be here today.
Okay, and you did testify that you, when you got the notification that you stopped the rentals and you didn't rent anymore. And
immediately.
And then it was our codes staff member had said that there weren't documented stays after the letter received. So that is that jives with what he said.
Yes.
So, all right. Anything else that?
Just that, yeah, I mean, in COVID, you know, we're not overly eager to be renting to a number of people at any rate, but I certainly would like to maintain the permit, you know, for a time when it's more appropriate to do that.
I believe the permits, though, have an expiration date on them, and I don't know that you should rely on a letter from Metro Codes to...
Okay, I think I just need to mark my calendar when it's approximately due so that, yeah, I'm not depending on someone else to tell me.
Yeah.
Okay.
Exactly.
Mr. Chairman, for our newer board members, the law does not and has never required the Codes Department to send any notifications of when the exactly 1-year permit will expire. Preview, it's 1 year from its issuance date for everybody. However, the Codes Department has always used courtesy notices that they send in the mail. Somebody doesn't get one, and that does happen, and a lot more people tell us that it happens than actually happens, I am confident. Not the case here today, but again, we deal with about 5,500 of these, so we hear a lot of stories. Nevertheless, we do send them. I've been in the office every day since March, And our staff busts their butt to get those out the door on a regular basis, despite the fact that they're not legally required to. It's a one-year permit, and for all of the 5,500 small business owners who have deadlines for taxes and permit renewals and things like that, we do encourage them to calendar that. It's a pretty good way to run the business. Granted, we don't know about running businesses here in government, but again, we hear that that's important sometimes. So it's happy to take any questions from the board members at this point if need be.
Well, and if I'm sure there are probably some folks that didn't get their letter that actually renewed it, but we probably hear 4 or 5 of these a month, and that's maybe 60 or so a year, and that's a little more than 1%. So that might correspond with an error. So I mean, there's not a. You're right. I mean, it seems like I think you guys do a really good job of getting that information out to folks and getting the response back. The minority is. I mean, this is a minority situation in terms of the folks that probably actually do renew versus the number of cases that we hear. But again, and all that you said is absolutely factual and true, and I agree to 100%. Any other questions or thoughts for the applicant? Anything else you need to add?
Not really. I just, I'd like to do whatever's necessary to be able to reinstate the permit.
Okay.
And then I'll make sure in the future that I do what you suggested, sir. And,
great. Awesome. Thank you. We will close the public hearing. Thoughts? Well, I mean, did you have a thought? You press the button again. You know what I want to say, so if you want to say something different, you can.
I was just going to say that I believe the applicant's testimony, and it seems like they've done everything to comply. I also believe that it's incredible that the Codes Department does something that they're not legally required to, and so I always want to say that I appreciate that, because a lot of times people don't do that. So I would just make a motion that because of the applicant's compliant history and willingness to take it down so immediately, that she be allowed to apply 2 weeks after the Thanksgiving holiday, so 2 Mondays after that. I don't know what day that is. I think it's like first full week of December.
You mean December 7th?
December 7th. Thank you.
All right.
The applicant be allowed to apply for her permit on December 7th.
And I like December 7th. It's
Okay.
a good day. No, they always have the military channel going that day.
It's a date that'll live in infamy. So the motion, and there's a second. Is there any other discussion? All right, all in favor, raise your hand.
We did have a finding that the administrator was correct in his actions.
Yes.
Okay, just making sure.
Yeah, the zoning administrator did an error, and the applicant's allowed to apply for another permit on December 7th.
And the record shows that they go beyond their
Ross, are
necessary.
you in favor of that?
Yeah.
Okay, I didn't look, I mean, everybody else was voting, and then he said, so that passes unanimously. You do not have a permit at this point. You have to reapply because it expired, and you're able to reapply on December 7th. So don't rent, advertise, or anything until you actually get that permit in hand, but you can apply for the permit December 7th.
Okay, thanks so much.
And with that, we're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.